Okay, let's dig into this. Imagine yourself in a courtroom. I mean, the spotlight's totally on you, your credibility's on the line, and the judge. Well, the judge seems determined to shut you down.
It's a really intense scenario, and the sources we're looking at for this deep dive, they plunge us right into that kind of pressure cooker situation.
They really do. They lay out this story of Caroline Levit facing this huge public challenge, and then this really dramatic intervention by attorney Pam Bondi.
Yeah, and what's so compelling in these accounts is how they detail not just, the personal drama, but the layers of legal strategy. This deep dive, it isn't just about recounting events. It's about pulling out the core insights from the source material on how truth, resilience, and frankly, smart legal moves play out when credibility and authority crash.
Exactly. Our mission here is really to help you distill the important nuggets from these sources, lessons about navigating those moments when you have to defend your truth against a powerful challenge, often using the formal legal process itself.
Think of it as sort of dissecting a high-stakes legal fight where knowing the rules and using them can be your best weapon.
All right, let's dive straight into the scene the sources paint. Courtroom 4, Eastern District of Virginia. The material describes it as just packed. Standing room only, apparently.
Yeah, reporters, lawyers, aides, everyone crammed in, sensing something big was about to happen. You can almost feel the tension described.
And right in the middle, Caroline Levit on the witness stand, described as looking remarkably composed, actually, and Judge Douglas Whitaker up on the bench. The sources kind of portray him as preferring control, maybe even a bit of intimidation.
And the conflict sparks almost instantly over something seemingly small, right? Caroline, under oath, corrects a fact she thinks was misstated.
But the judge, he sees it differently. He takes it as an interruption, as disruptive.
It really shows that razor's edge in court, doesn't it? When does sticking to the facts under oath cross the line into perceived defiance? The sources make it pretty clear the judge saw it as a direct challenge to him.
And his reaction is fast. And according to these accounts, really quite severe. He apparently slams his hand down on the bench. The source says the sound just echoed.
Finds her in contempt of court. Just like that.
Which means basically he's ruling she deliberately disobeyed or blocked the court's authority.
And the consequence is immediate. He orders the bailiff take her into custody. You can almost hear the gasp the sources mention. Her lawyer objects overruled. The bailiff starts walking towards her.
The detail here is striking. Caroline apparently doesn't flinch, stays composed, stands up, adjusts her jacket, puts her hands behind her back like she's told. The sources mention the actual click of the handcuffs, sharp sound in the quiet room.
It's a real show of judicial power, right? Meant to be absolute. Even the prosecution lawyers look surprised, according to the accounts. It felt less like procedure and more like the judge making a very personal, decisive move.
But just as she's about to be let out, Pam Bondi stands up, and the sources note this palpable shift. You could feel the energy change.
She speaks, not shouting, but with this real presence. And she doesn't just object, she makes an announcement. The defense, she says, filed an emergency stay earlier that morning with Judge Matthew Harlan, another judge in the same court.
An emergency stay, filed before this whole contempt thing even blew up.
Exactly. The sources really stress this. It wasn't reactive. This stay, as the material explains, directly blocks enforcement actions like contempt custody orders. Pam Bondi had the stamped paperwork right there, presented it, demanded it go into the record.
Ow. You can just picture Judge Whitaker's face. Disbelief at first. He apparently says something like, "No such stay exists." But then he sees the document. Stamped, 9:45 a.m. The clock in the courtroom, 10:02 a.m.
And that timestamp, that's crucial. The stay was officially active before he made the contempt ruling, before the custody order. The sources describe Whitaker seeing the time, sort of stumbling for words, then calling a 10-minute recess to go review the filing himself.
So for those few minutes, the accounts say, the whole power dynamic just flips. The stay holds. It legally stops them taking her into custody right then, although the sources mention the handcuffs stayed on during the recess, interestingly.
Yeah, it wasn't just Bondi reacting quickly. The sources showed the defense team had actually anticipated this kind of aggressive tactic from the judge. They were ready with the procedural counterpunch.
That really underscores a key lesson from these sources, doesn't it? How being strategically prepared, knowing the procedures, can counter even a sudden, overwhelming show of power.
Absolutely. Procedural readiness as a shield.
Okay, so court comes back after the recess. Judge Whitaker has to acknowledge the stay. He halts the contempt enforcement. But as the sources make very clear, this is far from over. The whole focus just pivots dramatically.
Yes, he announces they'll move to the evidentiary portion. Since he couldn't remove her with the contempt charge, the prosecution's strategy, now seemingly guided by the judge, shifts to attacking her fundamental credibility.
And the target becomes her public statements. Specifically, those job loss projections she made in a TV interview.
Right. To make that case, they call Andrew Keller. He's a senior labor market analyst from the U.S. Department of Labor, an official source.
Keller testifies he reviewed her TV remarks, and he highlights this big difference, her number. Around 450,000 projected job losses versus the Department of Labor's most conservative estimate, which was about 175,000.
That's a huge gap, over 150% difference. Keller testifies her figures were significant and misleading, not factually consistent with the official DOL data. The prosecution is trying to use the government's numbers to basically say she lied.
Okay, but the defense has a counter here. The sources detail how defense attorney Daniel Reeves handles a cross-examination. His strategy isn't really to defend her number as the absolute truth, but to pick apart the prosecution's witness.
Right. He gets Keller to admit that economic projections, well, they aren't exact. They can vary a lot depending on the models and assumptions you use. Different models, different results.
He also gets Keller to concede that the big national DOL figures often smooth out important regional or industry details, things that, alternative studies might capture more specifically.
And the really crucial point Reeves makes, according to the sources, is getting Keller to admit he cannot say her projections were fabricated or knowingly false. Pam Bondi's internal take, the material says, bulletproof on this. They could argue her numbers came from a different, legitimate analysis, not from an intent to deceive.
So the cross-examination kind of introduces that necessary doubt, that complexity. It's not just her number versus their number as right versus wrong.
Exactly. They use the process, the questioning, to show there can be multiple valid perspectives based on different methodologies. Yeah. Her number wasn't necessarily a lie, just different.
But the judge, he jumps in again. The sources point out Judge Whitaker specifically asked Keller a question. Did Caroline consult with labor experts from advocacy groups?
And this is where the sources really interpret the judge's move. They suggest he was fishing, looking for a connection to political groups, maybe a campaign finance violation hint, something beyond just the data itself. It showed his new angle. If data discrepancy wasn't enough, maybe political coordination would stick.
So court adjourns for the day with that hanging there. The defense team, the accounts say, they clearly see the shift. The fight isn't just about numbers anymore. It's about motive, about potential political ties.
Yeah, it shows how you have to adapt your strategy on the fly when the opposition changes tactics, especially when it seems the judge himself is pointing them in a new direction.
So how do you deal with a judge who seems to be actively trying to corner you from a new angle? The sources shift focus here, outside the courtroom, to the defense team's strategy meeting that evening.
And this is where Pam Bondi lays out her next move. It's not about going public, not about media pressure. No, she's doubling down on the legal process itself. The sources reveal she's already drafted a complaint for judicial misconduct against Judge Whitaker.
Wow. Filing a formal complaint against the presiding judge. That takes guts and a deep knowledge of the system.
It really does. And the complaint wasn't vague. The sources detail the specific grounds. 4 documented procedural errors by the judge already in the proceedings.
Things like, overruling objections incorrectly based on state law, blocking standard cross-examination lines, and that contempt ruling itself made before the defense had even finished presenting evidence. The sources framed these as serious breaches.
And the strategic brilliance, according to these accounts, was filing it under seal with the Fourth Circuit's Judicial Oversight Committee.
Under seal, so it's confidential, not a public accusation at that point. It's an internal move within the judiciary.
Precisely. The sources say the goal was accountability through the proper channels. It was about anticipating what Whitaker might do next and using the process surgically, as they put it, a precise internal pressure point, not loud public noise that he could maybe brush off as political.
The sources even describe the quiet filing, an early morning trip to the Fourth Circuit's admin wing, handing over the sealed envelope, getting that timestamp, described as the silent weight of accountability moving forward. Really evocative phrase.
It highlights that sometimes the most effective moves are the ones made strategically within the system, away from the cameras.
Okay, so court resumes the next morning. The sources mention the atmosphere feels different, less frantic maybe, more subdued.
And the prosecution makes its last big push to connect Caroline to political coordination. They call Melissa Hayes, a segment producer from Capitol Today, the show where Caroline gave that interview.
Hayes' testimony turns out to be pretty crucial for the defense. She confirms she handled the usual scheduling, the logistics, got general topic areas from Caroline's office, standard stuff, she says.
But the key thing the sources emphasize is her firm denial. She denies getting any guidance, any messaging points from any political advocacy group or PAC tied to Caroline. She's clear. All the pre-interview material came straight from Caroline's office. No political group influenced the content.
You can sense the prosecution's case weakening here, can't you? The sources note their confidence seems to dip. That narrative of a coordinated political message just isn't landing.
But what's telling, the sources point out, is Judge Whitaker keeps pushing. Even after Hayes is clear, he asks her directly, did you share findings with advocacy groups? Did Caroline's office ask you to tally the data for a political story?
Which confirms what the sources suspected, right? The judge is still fishing, testing the waters, trying to find any link to political motive, even after the witness denied it.
The defense lawyer objects this as going beyond the scope of her testimony. The judge just insists he's clarifying for the record, but the sources read it as him still searching for that political connection he seems to want.
But Hayes holds firm. Her testimony is clear, and the defense, they feel the momentum really shift their way. That whole prosecution attempt to imply some deeper conspiracy, it just falls apart.
Yeah. And as court adjourns, Pam Bondi apparently notes that the judge is now retreating into procedural language, using jargon, sticking to formalities. It's seen as a defensive posture now that his attempts to pin political manipulation on Caroline have failed.
Which leads us to the final day in court. Sources describe a subdued feeling, almost anticlimactic perhaps, after all the earlier drama.
Judge Whitaker gives his findings, and the key statements quoted in the material are pretty definitive. Yes, there were data discrepancies, but crucially, no evidence showed deliberate or coordinated falsehoods by Caroline Levit.
And therefore, no basis to impose sanctions or pursue disciplinary actions. So, on the core issue, the challenge to her honesty, she's cleared based on the evidence, or lack thereof.
He does add one final comment, though, notes his concern about her tone and approach during testimony, the need for decorum. A little dig, perhaps?
But Pam Bondi is right there to counter it. Respectfully, but firmly, she points out, citing the source, that those concerns about her demeanor were already dealt with by the federal stay. They cannot factor into any conclusion or public statement now.
And the sources note Judge Whitaker doesn't argue. That earlier procedural move effectively tied his hands on penalizing her for conduct in his final ruling.
The gavel falls. Hearing over. And then, the aftermath, as detailed in the sources. Judge Whitaker puts in his notice for early retirement the very next week.
Whoa. While the Fourth Circuit doesn't release findings on judicial complaints publicly, the sources state the timing of his retirement sent an unmistakable message within the legal community.
And Pam and Caroline's reaction, according to the accounts, no press conferences, no victory lap, just quiet dignity.
The way the press covered it, reflected in the sources, really captured the main takeaways. Caroline cleared, Bondi's strategy worked, it forced a review, and maybe most importantly, that process could still triumph over power.
Their own final reflection, shared in the sources, sums it up nicely. Caroline had the right principles, and Pam, well, she just made sure the law caught up.
It really wasn't just about defending a specific number. It was about defending integrity by skillfully using the rules, the procedures of the system itself, especially when facing down authority.
So, wrapping up this deep dive, we've followed this journey through intense courtroom pressure, from facing contempt, potential custody, to credibility attacks shifting towards motive, and seeing how smart legal process could completely change the game.
Yeah, the core insight from these sources seems clear. Truth matters, resilience matters, but combining them with sharp strategic thinking within the rules was absolutely key here.
The sources really position this as more than just one legal battle. They frame it as a lesson. It makes you think about challenges you might face. Maybe not in a courtroom, but situations where your word is doubted or someone with authority tries to dismiss you.
And in those moments, these sources suggest holding on to your principles, yes, but also understanding the available processes, the rules of the game, and acting strategically within them. That could be what makes the crucial difference in defending yourself effectively.
It leaves us with a really interesting question to ponder, drawn from these themes. When you feel authority is being used unfairly against you, how vital is it to not just rely on being right, but to actively understand and maybe even strategically use the formal procedures available to make your case and protect yourself?